Good afternoon. This is the special meeting of the Sunshine Ordinance Task Force. Can you call the roll, please?
Yes, Madam Chair. Member Craven?
Here.
Member Craven present. Member Nee?
Here.
Member Nee present. Member Cotton? Member Cotton present. Member Washburn? Member Washburn present. Member Caneva?
Here.
Member Caneva present. Member Johnson?
Present.
Member Johnson present. Member Chu?
Here.
Member Chu present. Member Chan? Member Chan absent. Member Goldman?
Here.
Member Goldman present. Member Williams? Member Williams is excused. Madam Chair, we have a quorum.
Can you call the first item, please?
Item number 1 is determination of jurisdiction on complaint filed by Paul Horcher against the Planning Department for being denied access to files associated with his client's appeal.
This came before the complaint committee, and we found jurisdiction on this item, and I suggest that this body find jurisdiction on it also. In the interest of full disclosure, I've met Mr. Horcher socially, but I don't feel that it'll affect my judgment in any way.
Is there a second? Can you call the question?
On motion to accept jurisdiction, Member Craven.
Aye.
Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cotton. Member Cotton, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan absent. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams excused. Member Chu.
Aye.
Madam Chair, we have 8 ayes.
I apologize. We did not call public comment on that item, and we purposely split up the jurisdiction from the hearing with the intention of taking public comment on these items. So is there any public comment on the jurisdiction of this item? I apologize for that. Could you read number 2, please?
Item number 2 is public hearing on complaint filed by Paul Horcher against the Planning Department for being denied access to files associated with his client's appeal.
Is Mr. Horcher here? Please approach the podium. Thank you. You have 5 minutes.
Hi, I'm Paul Horcher. Yes, we did meet randomly at a Korean-American restaurant over in Richmond. And didn't realize we had the same taste, but apparently likes Korean food as well. I'm Paul Horcher. I represent, a number of times I've represented acupuncture clinics that have an accessory massage use. And I represent them usually against the planning department who believes they've exceeded their license or they're doing too many massages and not enough acupuncture, whatever. I've been before the Board of Appeals many times, as has Ms. Tina Tom of the Planning Department. And one of the board members, one of the senior board members, which, as we both know, is very susceptible to the issue, is have there been any recent neighborhood complaints about the clinic? And with that in mind, I asked to see all relevant planning documents and was shown them around July 24th, 2008. I was shocked how thin the file was, extremely thin. I've been practicing law over 30 years. Some of you, I believe, are also attorneys. You know what I mean? I talk about a sanitized file. Extremely thin. I could find hardly anything in it. The hearing at that point was scheduled like 5 weeks later. It was postponed until October 15th. At the hearing, Ms. Tam misrepresented to the board and stated there had been recent complaints about the clinic. When I knew and she knew there had been no complaints against the clinic since January of 2005, which is was reflected in the file, which I'll show you later. She also admitted at the hearing that there were 2 files. There was a planning file and a so-called enforcement file. I don't know which one I saw, but I didn't see both files. After I filed this complaint with the Sunshine Ordinance Task Force, I saw the file once more, and still there's no evidence there of any recent any complaints about my client's business. So I know the testimony given was not true on October 15th, 2008 at the hearing. In fact, when I asked for a rehearing before the board, 2 of the board members realized there had been a miscarriage of justice and voted to grant me a rehearing. One of them was Commissioner Frank Fung, who was asked Tina Tam a number of questions trying to pin her down about some things that didn't quite look right in the file. As far as the timing, when were these entries actually put in the file? And she did not refuse to give him a direct, straight answer. Now, there was, as Mr. Goldman told you, we did have a preliminary meeting of the Sunshine Task Force, and At that task force meeting, Rachna of the planning department stated, quote, "I acknowledge that in July, the enforcement file did not have 4 or 5 lines of the full complaint information of the neighbors. Unintentional human error on my part, and I take responsibility for that. We made a minor error in July." You also have with you a document from the planning department called Memo to SOTF. Now, it's no bureaucratic trick. If you got to admit something, particularly something damaging, somehow try to camouflage it. You'll notice in this 2-page memorandum that the damaging statement begins in page 1 and the other half is on page 2. But you put that sentence together. In July, the department acknowledges that the computer records that contained the phone logs were inadvertently left out of the enforcement case file. In other words, they've admitted it. Now, also to show you, when I went in July 23rd, 24th, on or about the 24th, I was shown this document, dated July 23rd. And when I went back on November 6th, I was shown the same document, but it had been edited. Some of the history had been rewritten. I have that the clerk will distribute that to the board. You can see for yourself. I apologize, the text is so small, but there's been some material alterations to the record. Also, there's a corruption of the record, trying to make it look like she was telling the truth at that hearing, October 15th, that there indeed had been complaints.
Thank you, Mr. Horshaw. Your 5 minutes is up. You'll have another opportunity to speak.
Okay, thank you.
Thank you. Are there other parties of the complainant who wish to present facts and evidence? Seeing none, is there someone from the city to respond?
This Rachna from the planning department, the enforcement planner on this case. I also have Tina Tam and Christine Ha with me in case there are any questions. And as we understand that there are 3 issues in Mr. Horsher's complaint on this property: the number of files, neighborhood complaints, and thickness of file. On December 4th, the department had submitted a memo to the complaint committee responding to these issues. On November 9th, I appeared before the committee to speak to these issues. I will go over them again. Mr. Horsher came to review the files related to 4726 Geary Boulevard on July 23rd. He was given the enforcement file as it existed at that time. And at that time, a printout of our computer records in the file missed out about 4 to 5 lines of information about the neighborhood complaints, as our records were not updated at that time. It was like several months before the hearing, and we had not worked more on that case at that time, but he was given the file as we had. And this, I will just show you the portion that was missing at that time from the file, these lines at the bottom. And I realized that, it was missing, and we did not know at that time that it was missing. We realized that it was an oversight, and our records were later updated with this information and made available to Mr. Horsher, and then he came to see the files again on November 10th. And there's another issue about the number of files. In July, the appeal file did not exist. It was created later, and it was made available to Mr. Horsher when he came again on November 10th. And the third issue is about the thickness of file. Yeah, at that time, the hearing on this case took place in October, and from July to October, there were a lot of work done on this case, and we added more documents to the files, and the file became thicker. So those 3 are the issues. And on October 15, 2008, the Board of Appeals held a public hearing on this case. After the hearing, Mr. Horsher filed a rehearing request with the Board of Appeals, alleging that at the hearing, the planning department presented new information that he did not receive from the department when he came to review the files in July. On December 10th, 2008, the Board of Appeals held another public hearing and denied Mr. Horsher's rehearing request. The board determined that there was no new or relevant information to rehear the case, and the missing information about the neighborhood phone calls in July did not prejudice his case. To summarize, Mr. Horcher was given the files as they existed in July and again in November. We have provided everything that we had, and I would also like to add that, in my experience, like we deal with these issues all the time. We have hundreds of cases, and generally the concerned parties contact us from time to time to seek more information, just prior to, or before when there's a hearing is going to take place. We are always available to assist them in any ways, and whatever we have available to the best of our knowledge. And I acknowledge that we don't always have everything on top of our heads, but we try. And it is helpful when people ask specific questions and we can look it up more information for them. Unfortunately, after July and before the hearing, I did not hear back from Mr. Horcher, and he missed the opportunity to get more information. I'm available to answer any questions if you have.
Thank you. Is there other parties of the city that wish to respond? The matter is with the task force for discussion and questions. Erica?
For the representative from the city, if you could please come back up. So it sounds like you admit that there was a mistake made and that telephone log records of complaints that had been made prior to July 23rd were missing from the record. Is that correct?
In July, yes, they were missing.
Yeah, and
yes.
there was also, in addition to the 5 lines of text, it looks like there was also missing some text from February 20th, 2008 under the facts section.
Yeah, we update our notes from time to time,
So someone might have gone back and realized that in their notes there was additional text that they hadn't put in? Because there was a 228 entry, and that had 4 lines of text, but then it looks like there was an additional 4 lines added at some point.
Yeah, we added them, when the question came up as we discussed the case with the Board of Appeals, planner, then I realized that it was missing.
Okay. Has the department made any improvements to its record-keeping system so as to prevent this type of error from happening in the future?
We try, and we do have technical, sometimes issues, and our computer typing system sometimes doesn't enter information, it doesn't save it. Yeah, for sure, we take this seriously, and we are going to make more efforts to, improve it.
To prevent this. And my only other point would be that you seem to be relying on the duty of the complainants to come back to you and check in for new information, whereas in this case, there was information that should have been provided that existed at the time that was not. In that circumstance, I think it's incumbent on the department to contact the requester and say, we made a mistake, these are some extra records that had come up, these are responsive, here they are. So do you recognize that as a duty of the department?
I do recognize that, and I realize that as a courtesy I could have called him. It's just that I was so focused on preparing for the case, for the hearing, it just didn't occur to me that, I could have done that.
But can we have a commitment from you that, resources feasible in the future if the situation arises where, not where there's new information, because there's no duty on you to tell them about new information, but where you've discovered that you've inadvertently left out information that was covered by the request, where you realize that you will contact within your resources the requesters, provide them with that information?
Yeah, I realize that. I accept that responsibility. Okay.
Thank you. I think based on the records that there's been a violation of 6721A and C, would move to find an order of termination on those grounds. It seems to me, however, the department's admitting its responsibility, and therefore I wouldn't see any need to take further action on this matter. My only other comment is, and I'm done, thank you, I don't have any further questions for you, is that whether or not testimony given before another body was truthful or accurate is not something that's within our jurisdiction to weigh in on. It's really about whether or not the complainant was provided with the records requested that existed in the department. So that's at the appropriate time is the motion I will make.
Second that.
Are there any additional comments or questions? Respondent and complainant presents any clarification or rebuttal. This is a part of our process where first the city has the opportunity to present any other information that you might have, and then our complainant has that opportunity also for up to 3 minutes if there's anything additional you'd like to offer. Mr. Horchows or something? Thank you.
So I will make that motion to find a violation of 6721A and C.
Could I just make a suggestion? What about 67.24, withholding of information? Whether or not it was inadvertent, it was in effect withheld, and he did not have the opportunity to use it, so it materially damaged him at his hearing.
Well, I don't think I don't think that finding of material damage is something that is within our purview, so
Yes, but that's not my point. My point is that the material was in effect withheld, whether it was inadvertent or not. So I would simply add that as to the order of determination.
I don't believe they said it was exempt, and so usually 6724 comes up when someone says it's exempt for A, B, C, D, or E, or F. Here it was simply an omission, whether good faith or not, as can be disputed by the parties, but it was an admitted omission, so I'm not sure 6724, I would include it, but I'll defer to the other task force members.
If I have to repeat the second, then I do so here.
Okay. Let's take public comment on this item. Is there any public comment?
Members, Kimo Crossman, it's been a while. Good to see you again. I agree with the motion you have. I would like to suggest that you might consider adding 6729.7, which requires department heads and their respective departments to maintain and preserve in a professional and business-like manner all documents and correspondence. I think that's quite on point here. The city attorney has made clear that this provision refers not just to department heads, but to the departments that they oversee, and I can't imagine that this would not be relevant. I would point out that there's been other complaints about the planning department not providing complete files. You just recently had another complaint about that. So it seemed like a more common problem than just this one instance. And so I think the fact that they're not keeping them in a professional, up-to-date manner is a problem. If you look at what's happening right now with the investigation of Vice President Dick Cheney and Alberto Gonzalez with regards to wiretapping, one of the reasons that the Gonzalez is in trouble is because he took his notes 3 days later. He did them not contemporaneously. He didn't record them contemporaneously. And here it seems like something was not captured contemporaneously. It was recorded after the fact. And it damaged this gentleman's case significantly.
Ray Hartson, I'd like to agree with Mr. Crossman. Unfortunately, when something is added to the record after a copy is given to the person, it is possible to raise a question as to whether something was placed in the file which was done to change the whole setting of what was presented as the case of the planning department. I'm not saying that that happened, but it is a perception that someone could make that we looked at our records, we made a determination that there wasn't sufficient information in there to sustain our position, and therefore we'll go back and add this extra information. And instead of that being what the person relies upon, they now have this extra piece of information which is they're surprised with at the time that they're at the hearing. And and also what Mr. Crossman said, it is their city's responsibility to maintain the records, and if they are allowed to simply say, well, our maintenance system isn't up to date, and therefore we shouldn't be held to the responsibility of giving true and accurate replies to requests for information, I think that is a terrible precedent to set.
Is there any additional public comment? Seeing none, we're ready for the vote for the task force. Can you call the question?
On the motion, Member Craven?
Aye.
Member Craven, aye. Member Nee?
Aye.
Member Nee, aye. Member Cotton?
Aye.
Member Cotton, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
Aye.
Member Knebber, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan?
Aye.
Member Chan, aye. Member Goldman?
Aye.
Member Goldman, aye. Member Williams? Member Williams excused. Member Chu?
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you. Can you refer this item to the Education and Outreach to be handled at the chair's discretion? Can you call the next item, please?
Item number 3 is determination of jurisdiction on complaint filed by Alvin X against the Arts Commission for not releasing information on the number of black males and females employed by the Arts Commission and its associate groups.
Members, this item came before us in the complaint committee. We felt that there was jurisdiction. We found that, and we moved it to this body. I move that we find jurisdiction here.
Second?
Is there any public comment on this item? On jurisdiction of this item? Can we call the question, please?
Public comment?
Excuse me?
Public comment?
You missed it.
Okay. I blinked.
Item number 4 is public hearing on complaint filed by Alvin X against the Arts Commission.
I think we have to call the roll call for the jurisdiction.
On jurisdiction, Member Craven.
Aye.
Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excuse. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Thank you. Now we move on to the public hearing on this. Is Mr. X here? You have 5 minutes.
Yeah, another component of that was to get the specific breakdown of tax monies. For example, monies to the symphony orchestra. Understand nationwide the paid attendance to the symphony orchestra. Nationwide, attendance is down 26%. So I want to know, for example, what is the formula for giving to a symphony orchestra or symphony group, and how is viability determined? And of course, the absolute lack of black males over the years. They sent me some data, and I've called many groups, and it's very rare if I talk to black male. And quite often people will admit to me, no, we've never hired a black male, just others and black females. And that's the gist of it, the absolute lack over the years. I don't think that's coincidental. And so I'm trying to determine that the viability of giving money to specific groups such as dance troupes or orchestras. There must be a formula, and they did not submit the formula to me. And that's what I demand as a constituent and taxpayer. And I call the Controller's Office also. The Controller's Office, I believe, has that, but they claim that it will be difficult. Apparently they don't have that on the hard drive. I requested the hard drive. I could download that in minutes, but apparently they claim it's not that easy. And of course I called the Arts Commission many times, and again they claim they don't actually dispute my contentions, but they claim they don't have a reason, or they don't have the data. And I'm claiming they do. I assert they do have some data based on queries I made with several other arts groups, and that's it.
Thank you. Are there other parties that complain who wish to present facts and evidence? Seeing none, is this representative from the city here? You have 5 minutes.
Okay. Good afternoon, Nancy Goncher, Deputy Director of the Arts Commission. The documentation I have indicates that we responded to Mr. X on first on May 22nd regarding information, and there's a quote here from our director of our grants program, Sansan Wong. I'm writing in response to your request for information under the Sunshine Ordinance on May 13th, 2008, which I received on May 21st, 2008, about, quote, diversity efforts, end quote, in the Cultural Equity Grants Program of the San Francisco Arts Commission. She goes on to say that we don't have a specific document that talks about our diversity efforts, and she includes copies of our grant guidelines, which talk about the kind of groups that we fund and the procedures for funding, that is, grant panels that we conduct and that kind of thing. And she also directs him to our website and our cultural, and that we have a listserv and website which that have a number of downloadable documents. We don't have a list that breaks out our grantees by race. Part of our program, though, just for your information, is called Cultural Equity Initiatives, and it's to fund organizations, and this is a quote, deeply rooted in and able to express the experience of historically underrepresented communities such as Native American, African, Asian, disabled, Latino, LGBT, Pacific Islander, and women. And we give out up to around a third of our grant money to those groups every year. But that was not specifically what was asked for. So we did respond to that request on May 22nd. And then On November 4th, I got a handwritten postcard asking for information about black males who were employed at the Arts, or who were hired at the Arts Commission in the last 5 years. I responded to that on November 4th, 2008, with the list of the names of employees who had been hired in the last 5 years. But our city attorney advised me that we're not allowed to, for personal privacy reasons, to list the race of those individuals. I can say that we have had several African American employees over the years.
Great. Thank you. Are there other parties of the city that wish to respond? The matters of the task force for discussion and questions.
I have a question for Ernie Lorente regarding the statement that Ms. Gonchar made that she couldn't give out any information about the successful applicants. I'm wondering about 67. I'm on a 67.24 kick today. 67.24C says that a number of things are not exempt from disclosure, and included is sex, age, and ethnic group, education, and salary. I'm just summarizing it. Well, this is not the main event here today. I think it's something, if indeed Mr. Lorente agrees with my interpretation, I think that's an important thing to state, to make the department aware of.
Well, I think in terms of successful applicants, I think the ordinance does specify what can be released. Home addresses and age is not disclosable, but the other parts usually are. But in this particular case, that was not what was requested, so it's really not.
Right, I'm just pointing it out since Ms. Gonchar is here.
Well, we could refer to that section. I have them. I mean, it is. I know in terms of the educational feature of the task force, but you know, if it becomes an issue, then it definitely is something that we will address. But I think we just refer to that section for further consideration.
Okay, thanks.
Well, I had a question why it's not applicable.
Well, I think it's not applicable because the applicant, I mean, the complainant didn't ask for it.
The complainant asked for...
Number of black men over the past 5 years.
Right. And the reason that that Ms. Gonchar says she can't provide that information is due to protection of personal privacy. But it would seem to me that the provision that Member Cawthon is citing basically says you have no privacy in that information, that information for successful job applicants is public information.
Whether they're male or female, but right, he didn't ask for the male information about females, but just for the department's edification, this code section does indeed make this public information.
Right, which I think is different than state law. I think this is something, it's, as the section itself provides, this goes beyond state law in terms of what's required to be produced. And so where there's an explicit provision of the ordinance that requires it, then I think that information, needs to be provided, or at least the justification for refusing to provide it can't be on personal privacy, where it's explicitly included. So, I do think Member Cawthon has a very good point there.
I guess my question is, was the number of black men provided to Mr.
No.
It was not?
No. I said they didn't keep that kind of information.
The number?
Oh, and then they weren't going to give it out.
Well, it actually says, it may be that they don't keep the information. I don't see that in the November 4th response. I see, due to the protection of personal privacy, I'm unable to reveal any other information regarding these staff members. Along those lines, can I ask a question of Ms. Gonchar, please? Are there various equal opportunity employment EEO forms that the Arts Commission fills out with respect to its hires?
Well, the form that everyone fills out is the standard City and County of San Francisco employee application form. That does have an optional point at the bottom for race, but it's optional.
Right. And are those forwarded over to the San Francisco Human Rights Commission or any other agency that deals with tracking diversity in hiring by the city?
No, we're not. The Department of Human Services may. The Arts Commission doesn't routinely forward those on. That's not a requirement that I'm aware of.
It may not be.
Yeah.
I actually don't really know how it works. I know that there's somebody in the city who's tracking
Right.
that sort of information, but I'm not sure how it breaks down or whose responsibility it is. But as far as you're aware, it's not one of your responsibilities.
Right. Correct.
To the extent that those applications for employment, someone voluntarily or optionally provides that information in terms of ethnicity, I would think that those records, therefore, would disclose, because we're dealing here with primarily records, but it's also information, those records would disclose some of the information that he seeks. Maybe not give him a full answer to the extent that someone declined to fill out that box, but it would provide some of that information. So I'm inclined to find not necessarily a violation, but maybe hold this over, send it to compliance and amendments for a determination or resolution of whether or not those forms that are in the possession of the Arts Commission, therefore that it's information that they possess, disclose the employment of black males in the last 5 years, and such information could be turned over to Mr. X.
Are there
Any
any
other
other questions?
question?
Make the motion. Ed? I'll second it.
I think we make a motion. Do we make a motion now?
No, not yet. Now there's an opportunity for the respondent and the complainant to present additional clarification or rebuttal. Do you have anything else to say, Mr. X? Please. Oh, I'm sorry. The respondent has the first opportunity. Okay, thanks. Mr. X, please.
Clarification. I, at one time, did ask for others to make a objective comparison. That is, I asked for ethnicity, such as Chinese or females or lesbians, because they do, in fact, have some information. I asked for that to make a mathematical or objective comparison. But this time, the last time I sent, I just indicated black males because of information I had that there was an absolute lack of black males. So if they have a breakdown, and I'm sure they have a breakdown somewhere of ethnic groups or sexual groups where I can make a definite comparison to prove or disprove my assertion. That's it.
Thank you. Is there any public comment? Is there a motion? Sorry.
And just to make it clear, this can be discussed in more depth, and I'd like to hear the city attorney's position on C and what it provides in terms of release, because their position may be that the forms themselves can be released with the ethnicity information disclosed, but not the name of the applicant. I mean, there may be a number of ways in which the information that Mr. X seeks can be provided. Anyway, that was my point. I guess my motion would be to continue this, or not to continue this, but to refer this to Compliance and Amendments Committee to see if there's a way that Mr. X can receive the information that he seeks in terms of exploring with the Arts Commission what records they may have that could be redacted or otherwise produced.
Is there a second?
I second that.
I think there was a question to me regarding my position on this particular case. I think that reviewing, again, 67.24, dealing with personnel information, I think that the section is very clear as far as successful job applicants suggests that this information is disclosable. I mean, the question about whether it's the name, I think it may even be that the name is disclosable. I think only the professional biography in Section 2 of this curriculum vitae, home address, home phone number, social security, age, marital status shall be redacted. But the other features to it of a successful applicant are disclosable, according to this section.
So, Mr. X, at this point, what we're suggesting is that we help you through one of our committees to find what documents that the Arts Commission does have that will help, that will be responsive to the second part of your issue. Another option for you is to look into the Department of Human Services, which might have aggregate information about ethnicity in different departments. That's just an idea, and we can explore other ideas actually at that committee. They'll address the issue a little bit more broadly. I would like to address the first part of your complaint, which is unfortunately not something that we can what you asked for, in my view, is very clear. What you were looking for is to really understand a policy that the Arts Department, Arts Commission has. I think that their response is they don't have that written down, and that's as far as we can go if they haven't written it down, if there's no actual document. I do think personally that they should try and answer your question, that it's a valid question to ask. How are you working in this area? And that should be something that should be answerable. But unfortunately, this body cannot provide that for you. So that's why we're focusing on that second part of your question. Are there any? So we're going to go to public comment now.
Members Kimo Crossman, this gentleman asked for information. He did not receive it. I think you need to find a violation. It's fine if you want to refer it to another committee to help him find it further, but you're here to adjudicate this matter. He asked for the information. Departments are required to assist. They can't play gotcha if you didn't ask for it quite the right way, but they know what you wanted. They can't play gotcha. And I think there is a violation for not providing the information. At least they could have referred him to the Human Resources Department, I think, to possibly get more information from Human Services. Additionally, I think the provision for privacy is, clearly inappropriate here. So, there's not really good faith here. The other thing is there is a provision for oral information in Sunshine, 6721.22. No employee should be required to respond to inquiry or inquiries from an individual. It would take the employee more than 15 minutes to obtain the information. So you can ask for information under Sunshine, and he's asked for it. It doesn't have to exist in a document. It can be orally provided. And I think that you should find a violation that he did find it. Feel free to refer it out and try to work with him more, but the poor gentleman's been asking for this information for a long time. Now he has to wait another 2 or 3 weeks to come to another committee meeting to talk about it again. He should at least have the benefit of having found that there was a violation, that you confirmed with him that he did not receive the information requested and it should have been provided or assistance provided to find it some other way.
Is there any additional public comment? We're ready for a vote on the motion? Is there additional discussion?
I tend to agree that we should find a violation here. I think the best outcome would be to help Mr. X get the information, but I think the Sunshine Ordinance is clear that the information he asked for is information that he's entitled to receive. So I think we can do both, find a violation and refer this matter to compliance. So I'd like to make a motion to that effect.
Just ask a clarification. How do you see the violation? They're saying they don't collect that information. Through the chair.
I think that Allison is saying that they should have given them the applications, the successful employment applications. Is that what you're getting at? Because where would the Arts Commission find this information?
No, I'm certainly happy to vote on it, but I'm not sure that they say they don't collect that information. So if someone could clarify that for me, could vote with a little more ease.
I'm not sure they've said, and maybe I'm missing it, that they don't collect the information.
It's actually implied that they have it when they're saying they won't divulge it to protect the privacy of these people.
I think the testimony that I heard, and maybe Ms. Gonchar can correct it if I'm correct, was that they may have this information. It may be filled out in the section of the optional form for the standard employment form that applicants fill out or that successful applicants submit. Other than that information, would you have this in any form?
We don't collect this information. If it's on the form, which is optional, we might still have those forms. We don't routinely save all application forms in the personnel files. So, but I would have to check to see.
Right. So that to me is why that was the basis of my position, that there wasn't a violation necessarily. I mean, the question is, do they have this information in the personnel forms? Have they kept them? Is it in their custody? Does it disclose that there are any black men who have been hired? So that's why my inclination was to refer it to compliance and amendments. But I totally understand if the position is that maybe they should have, your position may be that they should have done that in advance before giving a response, and therefore there was a violation. So I refer, I defer to Ms. Washburn.
Well, my opinion is that they say they don't collect information about diversity efforts. While the ordinance certainly requires them to give a lot of information about successful hires, but I think that's another issue. I just would like to know where they. I think referring it to compliance and amendments is good, because then it can be determined if they have this information in some other form, and maybe they can report if they do collect anything at all about ethnicity, and perhaps they can reveal it without revealing the name. But I wish someone would tell me where the violation is on diversity, on not revealing information they have about their diversity efforts.
Well, the violation was what was mentioned, that the Sunshine Ordinance says that that kind of information is public and can therefore be accessed by the public. So we're talking about, I can see where the Commission isn't tracking all of the data for grants that they're giving out, but for the hires, of which there are less than a dozen here, apparently that information does exist, if nowhere else, in the memories of people who work with these individuals. But I don't think it's an onerous thing to ask, and the information for many of these people may exist, and Mr. X had the right to receive that information. So, in the scheme of things, this may not be a terribly egregious violation, but nonetheless, I think that it is.
Hanley?
Did she direct Mr. X to a proper department? No.
Did we have a second on Allison's motion?
I'll second it.
Okay. I will vote against that, simply because I think that the Arts Commission didn't think of looking at the documents that were available, and I'm concerned about other people making assumptions about other people's race. So, I live in, my kids are biracial, and I live in a biracial world, and I couldn't tell you the race of people I meet often. Please.
I mean, that's my concern as well. I don't know what they're supposed to collect on this. I mean, other things, but when you talk about race, it becomes a personal issue, what people declare themselves as, what they put down. So it's a little bit more problematic, I think, than cut and dry information. So I have a hard time voting for that as a violation.
I agree with that, too, and that was a really thoughtless comment on my part, as I'm going to have some biracial grandchildren soon. So that was very thoughtless. But nonetheless, there are employment applications where that information is gathered for those who want to supply it. And I think Mr. X has a very valid issue that he's grappling with.
Or she should have referred it to the right proper department.
So, I'm a little bit confused here. We have two motions on the table. And both of them were seconded, right?
Yes.
Okay, so are we going to vote on the first motion is to refer it, and the second is to find violation, right?
Right.
So you vote on the second one first.
Vote on the second one first.
And if that fails, then you go back to the first one.
Thank you.
So which one are we voting on? The violation first?
The violation.
Okay.
I would like to say something, please. I think that with a small number of employees, I don't know how long they keep everything, but the information may not be completely correct, since it's optional. So is gender in a lot of cases. So it's just that if someone volunteers that, it's in the spirit of assisting him in a way where she orally admitted here that over the past 5 years she can say that there hasn't been very many black males to her recollection. So that in itself is an assistance. So
I'm not sure that's what she said. I think she said that over the past few years there have been African American employees. If that's correct.
Not necessarily men.
not necessarily men.
Call the question.
On the motion against sending the...
To find a violation.
It's a motion to find a violation.
On the motion to find violation, Member Craven?
No.
Member Craven, no. Member Nee?
Aye.
Member Nee, aye. Member Cotton?
No.
Member Cotton, no. Member Washburn?
Aye.
Member Washburn, aye. Member Caneva?
No.
Member Caneva, no. Member Johnson?
Aye.
Member Johnson, aye. Member Chan?
Aye.
Member Chan, aye. Member Goldman?
No.
Member Goldman, no. Member Williams? Member Williams, excused. Member
No.
no. Madam Chair, we have 4 ayes and 5 noes.
The motion fails.
Motion fails.
Can you call the second motion, please?
On the second motion, Member Craven?
Aye.
Member Craven, aye. Member Nee?
Aye.
Member Nee, aye. Member Cotton?
Aye.
Member Cotton, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Caneva?
Aye.
Member Caneva, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan?
Aye.
Member Chan, aye. Member Goldman?
Aye.
Member Goldman, aye. Member Williams? Member Williams, excused. Member Chu?
Aye.
Madam Chair, we have 9 ayes.
Thank you. Thank you all. We're up to number 5.
The public comment?
We took public comment. Yeah.
Item number 5 is public comment.
Oh, no. We're going to do item number 5 on the agenda, which is determination of jurisdiction.
Public comment wasn't itemized.
It doesn't need to be in a special meeting. To the chair can take public comment if she wishes, but it's not agendized. It's not required.
Either way, it's not 5 o'clock, so.
I love it.
I can call it number 5. Determinative jurisdiction on complaint filed by Chemo Crossman against DTIS and SGTV for not providing a spreadsheet in Excel format and the supervisor of records for not acting on the appeal in a timely manner.
Members, this came before us in the complaint committee. We feel that we do have jurisdiction, and I move that we find jurisdiction on this item.
Second.
Thank you.
Is there public comment on jurisdiction?
And I'd like to point out, I believe there was a dispute as to jurisdiction with respect to the supervisor of records, so this may be an issue as to which we would encourage them to speak if they're in attendance.
Well, it does not include supervisor of records on here. Oh, and the supervisor of records for not acting. Okay. Is supervisor of records here?
Are you going to be splitting this when you hear it, or are you going to have it on both parties at the same time?
I'd like to have it together.
Through the chair, do we have any information if the supervisor of records is going to be in attendance or someone from DTIS?
Through the chair, the city attorney is on the way. Deputy city attorney is on the way.
All right.
That's fine. Let's just take public comment on number 5, on jurisdiction.
Sorry, so the city attorney is coming to speak to that? Is that what I heard?
Mm-hmm.
Okay. I would ask that you find jurisdiction on this matter.
Thank you. Is there any other public comment, or is there any public comment on jurisdiction? Seeing none, can we vote on jurisdiction, please?
No, the city attorney is...
The city attorney
The city attorney just arrived. I believe she might want to address the task force on the issue of jurisdiction.
Do you want to discuss the issue of jurisdiction?
But she may not.
Thank you, Commissioners. Just to point out that this is not your normal complaint procedure. The Sunshine Ordinance sets forth a procedure where a department withholds a record or claims an exemption, and you have a procedure for dealing with those. As far as I'm aware, this is the first time the supervisor of records has been called before the commission for other than the annual report on the supervisor of records. You have broad jurisdiction to hear any matter, I think, relating to the operation of the Sunshine Ordinance, but I just want you to be aware that this is a somewhat unusual situation and different from your routine complaints.
Thank you.
And I just want to make a comment. I'm sorry. I guess we should have the complainant respond before I make my comment.
I would like to ask that this item be split because I think there's going to be significantly different issues between withholding of a record and failure to respond by the supervisor of records to an appeal.
Okay, is there a motion? Did you have a comment?
I had a comment on the issue of jurisdiction. As I read the Supervisor of Records response, I recognize that there's an issue that this is perhaps not a typical complaint, but I do believe there have been complaints against the Supervisor of Records in the past, and I do believe it's within our jurisdiction to hear a complaint about the compliance with the section of the ordinance that deals with the Supervisor of Records. My main point was the information in our packet and the justification provided by the Supervisor of Records as to why we didn't have jurisdiction I found particularly problematic. It was a very technical argument that the complaint had been submitted under 6721, I believe, D, then let me double check that so the record is clear. I believe it was under E. The argument that Supervisor of Records put forward as to why we don't have jurisdiction was that the complaint specified 6127E as the grounds for the violation, whereas perhaps it should have meant 67.21D, which deals with the Supervisor of Records. I find that an overly technical complaint as to why we may not have jurisdiction. We are a body that's here to hear the substance and the gist of complaints, requiring someone like Mr. X, who is just here, to comply with specificities and cite sections of our ordinance before they can bring a complaint and establish jurisdiction, to me is uncalled for and not within the purpose of why we're here. I believe that we give a generous read to complaints, and as long as they give the gist of the allegation to the department so that the department can accurately respond to that complaint, that's sufficient, and that we need not hold lay people who come before us to the pleading standard, for example, that an attorney would have to meet in a court of law. So I just had some concerns about that jurisdictional argument and wanted to make clear at least my position on that, but I do believe we have jurisdiction.
Not at this time. Thanks. Let's call the question on jurisdiction, please.
On jurisdiction, Member Craven.
Aye.
Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson. Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams excused. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 9 ayes.
Great. Now we move on to the public hearing. Mr. Crossman, you have 5 minutes.
Thank you. Thank you for finding jurisdiction. Members, in my effort to get to the bottom of the digital recording issue, the mandate that's in Sunshine, I put in some records requests back in October to SFGTV to find out how they're using their staff and so forth. And that actually informed my recent op-ed in The Guardian that you might have seen this week, stating that there are no costs to the city to do a digital recording and post it online. But nonetheless, it was very difficult to get this information from SFGTV. They had delayed me, and I had to wait quite a long time. Eventually, they gave me a PDF of the spreadsheet, of how the staff are scheduled there, and I asked for the actual spreadsheet, and they refused to provide that. They eventually gave me a tab delimited version of it, but that extracts all the formulas that are in the spreadsheet. They indicated, I asked them to give me to write up all the formulas as an incremental response, not a complete response, and they indicated most of them were some formulas. But there's lots of information that's in a spreadsheet, even if you provide the tab delimited version. You don't get the formatting, you don't get what cells are hidden, you don't get macros, and you don't get assurance that their claim that all the formulas are some formulas are really some formulas. So you have recently, over the last couple of years, some of you are new, but the task force has ruled very thoroughly on providing Word documents in their original format, their native format, and you've consistently come down on the side of the public to give them the document based on, if nothing else, the utility of having a fully usable spreadsheet or a Word document. Now, some of the claims that are made here are that that the spreadsheet might contain information that might affect the original. Well, first of all, it actually has to. You can't just say claim that it might. You have to say that there is specific data in this specific spreadsheet that will affect the original, and that has not been asserted here, nor would it be believable if it was. And eventually I appealed to the supervisor of records, and I've been having problems getting assistance from the supervisor of records. She delays my responses. She goes on vacation for long periods of time, and you see the written response here where she said, well, the wrong person's not in the office, wait another 2 weeks. Well, that's just unacceptable. The Sunshine Ordinance is very clear. 7 days is the time required for responding to an appeal. Also, if you look at what the supervisor of records uses, supervisor of records has said that they want it to be, the city attorney has said that supervisor of records should be, have their own ethical wall in the city attorney's office. That's based on a memo from 2000. And yet, the supervisor of records basically applies the memo that Balzarevsky, which you previously have found to be invalid, as justification. So rather than looking at the law afresh and anew, she applied the memo. And by the way, that is just a memo. It's not an opinion. The city attorney has very specific procedures for what is an opinion, how it's reviewed and approved, and eventually signed by Dennis Herrera. This memo about Word versus PDF, and again, it was only about Word versus PDF. This memo was never signed by Dennis Herrera. It's not an opinion. It's a memo. It's advice, and invalid advice that you found it to be. So I would ask that you find DTIS in violation for continuing to refuse to provide the spreadsheet, and that you find the supervisor of records in violation of not responding to a timely response, as well as not enforcing 6721E, which requires her to provide, assist in providing the record within those 7 days if she determines that it's disclosable, which it should have been. Thank you for your time.
Thank you. Are there other parties of the complaint who wish to present facts and evidence? We're ready for the city to respond. How many representatives of the city do we have? 2? Great. We're going to give you each 5 minutes to discuss your part of the complaint. And then at the end, Mr. Crossman will have the equal amount of time, minus the 5 minutes you just used.
Thank you for your time. My name is Barry Frazier. I'm an analyst with the Department of Technology, and I'm representing Department of Technology and SFG TV. We submitted a support letter with some attachments, which you should have in your file, which I think lays out our position on this matter and our concerns with providing documents in Excel format. We did provide a PDF copy and a tab-delimited text file copy and a description of the formula involved in the original, included in the original Excel spreadsheet. And we did rely on the September 19, 2006 City Attorney's opinion to withhold the original Excel format file. We believe that although that opinion only applies specifically to Microsoft Word files, that the arguments and the reasoning in that opinion should apply with even greater force to Excel formats. With respect to the document's integrity, one of the important concerns raised in that opinion was that a document that is released in its native format would be subject to manipulation and tampering. I think that goes it's more important and easier to do with an Excel spreadsheet, especially if you have formulas. You can add a couple of zeros in one cell and essentially change the numbers for an entire spreadsheet. So we do have concerns about maintaining the integrity of the document. It's also very difficult to find a very small change in an Excel spreadsheet like that to determine whether it's been changed or tampered with. There's also the question about hidden data, or what's so-called metadata, which is raised in the city attorney's complaint, is also a concern with Excel, the Excel format. All of the same problems that you have with a Word document you have with an Excel document. So there should be no difference in the analysis or the determination of whether or not the the documents should be disclosed in their native format. And I think the supervisor of records email on December 3rd comes to that same conclusion, which we also put into the file. There are a lot of different types of hidden data that could be protected from disclosure that could end up in an Excel spreadsheet. You have to remember that Excel spreadsheets don't include just numbers, but you can put text into a cell. You can include all types of textual information that could be privacy related, could be preliminary recommendations for a draft, could be confidential or privileged attorney-client communications. But the biggest concern that we have with the Department of Technology is the fact that with all of these types of Microsoft documents, there are places where hidden file information, path, text file names, locations on servers, those types of things can be hidden in metadata in both Word files and Excel spreadsheets. And we have a concern anytime we are forced to disclose information that might contain anything that would make it easier for someone who is tampering or unauthorized, got into our system, our network, to make it easier for them to find information. And that is why we have a concern about this, about providing these files in their native format, because it is possible and is likely that file paths and information about the location of these particular documents will be made available. We are working on ways around this. It's very difficult to strip out that type of data because many times it will affect the actual numbers in the format, and it becomes much easier to convert the file to a text-delimited file, or a comma-delimited text file, or a tab-delimited text file, which keeps all of the numbers intact, the values intact. And as I said, we are willing to provide descriptions of what the formulas are that have been taken out. That seems to be the best solution that we've come up with so far to try to deal with this concern. I'd be happy to answer any questions that you have about this. It is a fairly technical issue, and so if you have any questions, please feel free to ask.
Thank you.
Thank you.
I have a very...
We're not going to ask questions yet.
Oh, okay. Members of the Commission, on the substantive issue of the Excel spreadsheet, as you know, this office issued an opinion in 2006 and elaborated on it in 2008 in the context of the matter that came before this Commission on the charges against EDU. And there are essentially two arguments in that opinion that I'll just repeat. The first is a concern with the process that departments would have to go through to see if there were privileged information in the metadata that either was required to be deleted because there's a legal duty to do it, or that there was a discretionary ability, if there was metadata of a certain type, not to disclose it. And the burden on departments of having to go through the metadata to search would be extremely onerous. And we think, given the size of the city, the number of document requests, the limited number of people available to do that kind of search adequately, is unreasonable. And as we've said, the courts have recognized that there's an inherent rule of reason in construing the requirements of sunshine laws. And we think that applies. It clearly applies under the case law to the Public Records Act, and we think it is, a court would extend that as well to the Sunshine Ordinance. And we think it's an inordinate burden that departments need not go through. They may, but they need not go through. And the other issue is the integrity of the document itself. And this is a concern that's recognized under the Public Records Act with respect to electronic records. Mr. Crossman has argued before and argues again that the opinion of our office on Word versus PDF is not a city attorney opinion. It's been on the website several years now. We've said before and we'll say again, this is an opinion of our office, not every opinion of the city attorney. Dennis Ferrer doesn't have to sign every one. It's been authorized to be up on the website. It's an opinion of our office. we see no reason that the reasoning of that case wouldn't apply to the Excel spreadsheet. The same issues arise, both the integrity of the document and any metadata that needs to be looked at before the document's released. The procedure that our office uses, the ordinance provides that the office is both the legal advisor of the city, responds to public records requests, and is the supervisor of records. When a petition is filed with the supervisor of records from another department, such as the Department of Technology, another deputy may have advised the requester, but the supervisor of records has not. So as supervisor of records, I or whoever else is in that position takes an independent look at it and considers independently whether the reasoning is applicable and correct. And in this case, I, as supervisor of records, determined that it was, and I think reasonably pointed to and relied on the opinions that had already been issued. On the timing issue, as I've mentioned, again, I want to go back to the rule of reason. We have an obligation in our office, and I think all city departments do, to not allow one or a limited number of persons to monopolize the time of a department, so it can't give the service in the limited number of hours in the day that we have to provide services to all of our clients that serve the city and county of San Francisco. We have informed Mr. Crossman, I think it's been about 3 years now, we told them that we're going to limit the time we spend on his requests because they are so numerous. We respond to him. I respond to many, as you know, supervisor of records appeals. We will see even more, and there's 3 times as many this time as there was a year ago. But we do not always respond within the 10 days because of the burden that he places on the city and on our office. And another point about there are some times when the supervisor of records goes beyond the 10 days. Sometimes it takes that long to talk to the right people, to consider the issues early. And again, we don't think the drafters of the Sunshine Ordinance or the voters intended to have us issue an opinion that is timely but ill-considered.
Thank you. Mr. Crossman, I believe that's an extra 5 minutes.
Okay, thank you. First, let me just remind the members who have not been on task force as long as others. This issue about Word versus PDF, Excel versus PDF, this was thoroughly dealt with by task force last year or two. The Board of Supervisors even eventually issued a motion to the clerk of the board telling the clerk to give documents in the format requested. It was a unanimous motion. So they rejected the city attorney's opinion or memo. The plain facts are as follows. The memo that the city attorney has on the website is just a memo. They have very stringent procedures for an opinion, which required the city attorney, Dennis Herrera, to sign it. He has not signed it. It's not an opinion. The other thing is that this is not the first time that I've had trouble getting a reasonable response from the supervisor of records. She consistently misses the deadline for responding to an appeal. I finally decided I was going to file a complaint about it because it was happening so frequently, and because of this, there's a written record of it here where she says, I'm not going to respond to you for 2 weeks because I can't talk to the right person, blah, blah, blah. The other thing is that what you've heard from DTIS is a lot of could be, might be. He didn't tell you that this particular spreadsheet had metadata in it that would be dangerous to the city's network system. And this is what we all talked about before when you found in favor of getting Word documents. Secondly, there are free programs for Microsoft Excel and Word to remove hidden data. It's a free add-in. You can download it, run it, and it extracts your metadata. It's no problem. Snap. And this issue about, well, we're afraid that the spreadsheet might be changed. Someone could edit the spreadsheet. I've talked to Terry Frank with Callaware about this. The CPRA is very clear. That language is about modification to the original document, not the copy that I get. This is about if revealing the electronic document would give me an ability to change the original that's still on the city server somewhere. That doesn't make any sense that you could modify a copy and that would somehow change the original. It doesn't change the original. If someone wants to validate some report I write later on based on the spreadsheet that I say I got from DTIS, then the way they validate is they go back to DTIS and ask for another copy of the spreadsheet. So that's the way you make sure you get a copy of the original. Let me point out to you that there's many documents that are sent to you that have the footer in it which has a file path on it. It's a fairly common process. If it was such a dangerous thing, you can assure that security departments from around the world would not allow that commonly to be used, and in fact, Microsoft wouldn't even allow that feature, the footer file path name feature in their Word document to be used. I think the thing that makes me saddest about the supervisor records is that the memo from 2000, I think Jackie Miner's memo, said that they were going to treat the supervisor records as having the ethical law just in the same way as Mr. Lorente, even though that's not required by the ordinance. And yet when you see her analysis, she doesn't do an independent review. She doesn't look at any of the case law that I cite. She doesn't respond on a point-by-point basis about them. She just says, I looked at the memo, but she calls them an opinion, and I'm going to go with that. She didn't respond to all my points and find why she didn't think they were legitimate. Let me just point out to you, 6253B in CPRA, that's a state law, says you are allowed to have an exact copy of a document. I asked for an exact copy. I have still yet to receive it, and I would ask that you find that DIS was continuing to withhold this document, and that the supervisor records did not do her job to respond within the time frame allowed, and then to follow up and get the document for me. Thank you for your help.
Thank you. The matter is with the task force for discussion and questions. Rick?
Could I
Please.
I have a couple of comments. I find the arguments by Mr. Fraser from DTIS and from Ms. Jessen, the supervisor of records, to be rather specious. I hate to be so blunt about it, but that's my opinion. It's unfortunate that Mr. Fraser has chosen to rely on a 2006 memo rather than referring to the city attorney on this particular matter. He could have done so. Second, again, that 2006 memo is one that the task force has found consistently violative of the California Public Records Act and the Sunshine Ordinance. I think both of those statutes make it abundantly clear that the discretion on format for release of public documents does not rest with the respondent agency. It lies with the requester. And for the city, for the supervisor of records and various city agencies consistently to flout that. As far as I'm concerned, it's an affront to the law and it's an affront to the task force. It is, Mr. Fraser voiced concerns about information that should not be disclosed, that perhaps there is in the metadata information that should not be disclosed. We're not talking about perhaps here. We're talking about what is and what should be. And Mr. Fraser has not presented any evidence at all that there is any data within the information that Mr. Crossman has requested that may be withheld or should be withheld under law. And as Mr. Crossman has pointed out, there is software that is easily available that is that can be used to scrub metadata. There is also provision in law, in both the Sunshine Ordinance and the California Public Records Act, that where a record contains some information that is disclosable and some information that is exempt or prohibited from disclosure, the requester has a right to that portion of the information that is disclosable. And therefore, it is up to the respondent agency to do the necessary redactions and deletions and any editing that is necessary. I will stop there.
Thank you for your
Yeah, I
patience.
just had
the question I wanted to ask Mr. Frazier, which is sort of on the lines of what we're talking about, but I'm not an expert on any of this, so I wanted to go back and rephrase it again. I have read, I'm familiar with the Mr. Zaretsky's memorandum. I'm also familiar with the decision made in the Gloria Young case, which was that, and confirmed by the supervisors, that Word it was appropriate to provide Word versus PDF. Now you're making, this is a different sort of case in my opinion because we're asking for an Excel spreadsheet, and our city attorney makes that distinction. He refers us on page 49, he refers us at the bottom, he refers us to the previous ruling in the Gloria Young case, but he says there is a distinction here, there could be a distinction here because we are talking now about an Excel spreadsheet which has to do with numbers and the possibilities, if I'm interpreting him correctly, the possibilities for tampering with numbers are greater. So that's my number one question. Are you equating sensitive information in Word with sensitive information in Excel? And the second question is that Mr. Crossman and Mr. Neal so referred to programs that can scrub metadata. So number one, are you equating scrubbing Word and scrubbing Excel financial information as one thing? And what about these programs that scrub metadata? That's my second question.
First, I'm a policy person. I'm not a computer programmer, so I'm not the real expert here either. But my understanding is it is much more difficult to scrub an Excel spreadsheet because you have formulas, you have sometimes documents that links to other documents or other worksheets, and if you scrub the metadata, you will affect the links and you'll affect those formulas, and you cause the numbers to be off, to change. So there is a problem with trying to scrub, especially links to other documents from an Excel spreadsheet. We are looking into other ways of doing this, and we're looking at some of those programs that I think, I don't know the names of the programs. We have found, though, that it's just quicker, more cost-effective, and easier for us to save the file as a delimited file. You get the very same result because you get the delimited file replaces the formulas and the links with the actual values that you see in the original document. What you lose are the formulas. You can't see the formulas. So we are willing to try to explain what the formulas were that we're replacing, so the requester can understand what we've replaced. But my understanding is it's much more difficult to scrub these kinds of things with an Excel spreadsheet because you have these links and you have numbers that will change if you tamper with the linking or the formulas or the other hidden data.
So, Mr. Frazier, you're making a distinction, as Mr. Lorente suggests there may be one, between providing material in Word versus PDF and providing material in Excel versus another format. Is that correct?
I believe so, yes.
Okay, thank you.
I think, just for clarity for the record, I want to handle each issue separately. With respect to the complaint against the supervisor of records, it's a timing issue. That's the totality of the complaint, was that the supervisor of records did not respond within 10 days. What is not before us is whether or not the supervisor of records reached the right decision. That's not in the complaint. That's not really within our jurisdiction. On that sole issue then about the supervisor of records and timing, I'm not inclined to find a violation. I think Ms. Justin had a reasonable excuse in this situation to require additional time. Both the PRA and the ordinance have provisions that with respect to electronic record, if there is exempt information, which we're assuming that for the moment, but if there is exempt information in a document, it can be withheld. And so her need to take 2 weeks to review that issue, to talk to DTIS to find out what was in this exact record, I think was appropriate. Turning to the more substantial and complicated issue, at least from the city's perspective, not from my perspective, about production of electronic records, I think there is no distinction here between a Word document and an Excel document, and the city's justifications are, as with respect to releasing Word documents, not well taken in my view. As Member Nee pointed out, might is never a reason to prevent disclosure under the Public Records Act or the Sunshine Ordinance. Both laws are clear. Information has to be exempt before it can be withheld. There has to be determination that there is exempt information before it can be withheld. That determination has not been made. The reason that the city attorney gave for not requiring departments to make that determination is a burden argument. And she cites, maybe Mr. Reski also cites the inherent rule of reason in response to PRAs. That line of cases deals with a needle in a haystack requests. For example, I'm going to request the city to turn over to me records regarding a specific event in 1993. In responding to that broad request, the city is allowed to use reasonable measures, and they're not required to turn over every stone, and that's where the rule of reason line comes in. What the rule of reason cannot do is trump a specific requirement in law. And there's a specific requirement in law in these cases that electronic records be provided in any form maintained or easily generated by the city. If the city attorney's office wants to disregard that law, and departments want to disregard that law on the basis of policy, on the basis of burden, the solution is to seek amendment of that law. They can't simply choose to ignore it. My final point would be the city attorney's position and the department's position here effectively nullifies the provision providing disclosure of electronic records. What record does not contain metadata? None. The PDF that was provided to Mr. Crossman itself contains metadata. It shows when it was created, how it was created, the data was created, the computer was created on. But they didn't choose to not release that document. If the fact that confidential metadata might be included in a record can prevent disclosure, those provisions are nullified. Every document, electronic document, doesn't have to be released, and those provisions of law have therefore no effect. That's a fundamental rule of law that says you cannot interpret something to undermine a specific provision of law, which is what their reasoning does. Same with the provision about alteration of the original. That concern, that provision in the Public Records Act that you don't have to release an electronic copy if it would jeopardize the original, goes to certain programs. I think the legislative history discloses this, that you have to run a program to produce a copy. And if running the program to produce a copy therefore alters the existence of the original, you may not have to do so. But if the city attorney's and the department's position is correct, again, what electronic record could be produced that's not alterable? That's the purpose of providing an Excel spreadsheet where someone asks for it. The purpose of this provision is to allow requesters to say, I want to see what formulas they're running. I want to take that spreadsheet and plug in my own set of numbers and see if I could find a way for the department to reduce overtime. I want to be able to have access to the same tools that they have to make my job as a public watchdog easier. That's the whole reason for the enactment of these provisions. The fact that I can get a spreadsheet and alter the numbers has absolutely no impact on the integrity of the original. If the city's worried about my copy and their copy, they can say, this is our copy. This is the one that's appropriate and can be introduced in a court of law. This is the one that can be introduced in an administrative proceeding. It's an authenticated version. We've kept it. My copy doesn't have that benefit or that seal of approval. It's my copy. Sure, I can alter it. That's the purpose of getting an electronic copy. If I want an electronic copy of a Word document that the city has produced so I can go in and footnote it and edit it and highlight it and color changes, that's the purpose of giving it to me in Word if I request it. So if they're right that you can withhold information because it might have metadata or you might be able to alter the document you receive, that would effectively nullify both provisions, and that's not the way the law is read. So I do believe that the city attorney's position and the department's position here is without merit. I believe there's been a violation like Member Nee. And again, I think that if the city attorney departments feel that it's bad policy or it's too much burden on the departments to be required to review or extract metadata, then they should go and seek a change in the ordinance or in the Public Records Act and not simply choose to ignore it.
Any other comments or questions?
I wanted to hear from Mr. Laurenti about what you meant at the bottom of page 49 where you review the previous young case and you say there may be an important distinction here because of the Excel, because of its numbers.
Well, I was concerned about not so much about metadata and words or information, but most about whether it would have some impact upon the computation of numbers, whether it would affect the integrity of the original document. That's why I raised that issue, but it wasn't, and I think that's been explained by the parties today. That was where I was coming from.
I think we should vote separately on the timing issue and on the metadata issue. I would move that we vote separately.
We only have one.
Sorry? I would move that we separate.
Let's see what motions we got.
Yeah.
Now it's part of our process to offer the city an opportunity to respond. We have a very detailed process that I follow. I have to read every time. The city has 3 minutes if there's anything you'd like to clarify or rebut at this time.
Just first, Member Nee, I sincerely apologize if I inferred that we didn't consult with the city attorney, that we just simply found this opinion and relied on it. But we did consult repeatedly with the city attorney with respect to how to interpret that opinion, and there was a lot of back and forth with respect to that. So I just wanted to clarify that point for you. The only other thing I just want to say is that if you decide that there is a violation here, it does put us in a real dilemma with respect to Excel documents, because to go through and try to scrub out the information will very likely change the numbers in the spreadsheet. And so we are either forced to provide the document with the links and keep our fingers crossed that we're not going to have a security issue, or provide a document that's been altered. And I just hope you consider that when you take your vote. Thank you.
Thank you. Any comments?
I'd just like to get in a comment I was trying to make earlier to Member Craven. I agreed in my response, said I agree you had jurisdiction. I wasn't saying you didn't have jurisdiction. I agreed your role under the Sunshine Ordinance is broad. I just wanted to point out that it's different from the normal complaint. That was my only point.
Thank you, and I'm sorry if I misconstrued your letter.
Thank you. Mr. Crossman.
Hi, thank you for the conversation. Let me just point out a couple things. One is that, let me repeat again, there's a free add-in you can download that lets you erase metadata from Excel spreadsheets. You can download it from the Microsoft website. Free download to erase metadata from spreadsheets. And I find it strange that Mr. Frazier earlier claimed he was just a policy person, but then he comes back here and tells you that if we give away spreadsheets, it's going to cause all the security problems. I don't understand. Either he's technical or he's not technical. I don't know. You know, one time he is, one time he's not. But the reality is that there are procedures, there are simple ways to provide spreadsheets, and you know what, spreadsheets are given all the time in federal FOIA places, in other states, other California departments provide them. It's not a danger to give out a spreadsheet unless you have embarrassing information in it. So the other thing I wanted to point out is that you can do tables in Word and they can calculate numbers. Word can do tables that calculate numbers that you can change, just like a spreadsheet inside a Word document. So the whole idea that someone could take someone could change a spreadsheet numerically, but they couldn't change a Word document numerically is not true. I mean, plus, what about all the Word documents that have numbers, totals in them? You can change them. It's the same thing. It can be adjusted, but that's not really a reason for not providing it, because it's about changing the original, as Mr. Craven said. Let me point out to you, that there's a bit of a distortion campaign going on here by the city attorney's office. They pulled out a memo from 2006 when I was asking for a lot of records. This was the only appeal that I had at the time to supervisor records. Only appeal I had. And this was the only request I had outstanding for DTIS. And yet, they could not find anyone at DTIS to consult with. This is the technology department. They couldn't talk with anyone else in the technology department to find out whether the spreadsheet was disclosable or not. They had to make me wait another 2 weeks. This, of course, is after they did, voluminous, they extended it and all that, because I didn't even appeal for it until then. So the whole point that, it's 2 more weeks is not a big deal, it is a big deal, because I asked for the document way before then, and then they claim, when I put it into her, she claims she has to talk to, there's only one person at the technology department she can talk to, and they're out for 2 weeks. I don't find that believable. I don't think that's believable. And I think that it does not set a good, the supervisor records of anyone should be diligent about following Sunshine. And the fact that she wouldn't respond within the time frame required, I would ask that you do find a violation on that, or at least caution her about that, because this is not the first time that she's made me wait. If it was the first time, it wouldn't be a big deal. But it's been going on and on, and that's why I finally complained about it this time.
Thank you. The matter is with the task force for motion and deliberation. Please.
I would move to find no violation against the supervisor of records,
Is there a
separating
second?
this out from the issues.
I'll second that.
Any other motions?
I move that we find the department in violation of 6721 for withholding the information.
I second that.
A friendly amendment, 6721L, and I would also cite Government Code 6253.9.
Is there a seconder?
I second that.
I agree.
I do have a question for Mr. Fraser, now that we have the motion on the table. Do you see the benefit of giving someone an Excel spreadsheet to really understand the information?
I do understand the need to have the formulas or have an explanation of the formulas, so I tend to agree that is a unique situation with Excel spreadsheets. However, I believe that you can explain the formulas and get the same result.
I believe that would be much more labor intensive. Do you agree?
Trying to decide, do I
Using the tech.
okay.
Okay, let me try it this way.
So, or am I policy?
If you I really want an answer. So
right.
if you gave a Excel spreadsheet to Mr. Crossman and he sent it back to you, would you consider that a correct Excel spreadsheet? I mean, you're saying that he could manipulate and tamper with that, and that someone in the city might fall for that?
I think the concern is that it could be tampered. I'm not saying Mr. Crossman would do this, but someone could take it and change the numbers and then represent it as the city's work. Right. And it would look very much different from what the original numbers would be, and it would be very difficult to detect some very small changes that would be made to make big differences in the totals.
Well, except for that, a thinking person, a reporter, for example, would probably look at where it's coming from and say,
One would hope so.
So So I believe in, believing people's intelligence and that they're going to do this. So here's what's going to happen is I think we're going to probably end up finding you in violation, I assume, and we're going to ask you to produce that document. And I beg you to look at this in the light of that one document, not as a policy, not as this is determining anything related to the city attorney or anything like that. I beg you to just look at that document, open it up on your spreadsheet, open it up on your computer, and use someone in the knowledge in your department to say, where is that metadata and what does it say? I beg you to look at that, because I think that a lot of us who have spent a lot of time on this issue think that you're going to go, wow, okay, it's a bunch of commas and stuff like that, but it's not actually telling them anything. I really believe that, and I beg you to actually go through that process, because what will happen is you'll in a month or so, we'll get to talk to you again, and I'd like to know whether that was done and what you found in that metadata that couldn't go out. And And what was the specific reason on that specific file that you felt that it couldn't be released? So
Certainly. 10 seconds. Our concern, we're an IT department, and we try to deal in best practices. And our best practices are that you try to protect information about file locations, file paths, directory structures, those types of things. We do have a big concern that a lot of Word documents contain that type of hidden information. And it's sometimes very difficult to find. If it's in a macro, it takes a programmer to find it, actually. And so we're concerned not so much with our department, but with other departments handing out documents that maybe have not been reviewed carefully. And so that we're just looking at what the best practices are.
this issue is about one file.
I understand.
And I would love for you to bring it in and show us where the information is. And if we have to do it in closed session or something, we're happy to do it. And you can show us what
Are you inviting
exactly.
me back? Or
I think
would you
we
like-
will. Well, not yet, but I think we will. So we would love to know exactly what in that file. You guys are a technology department. You also are employees of the city of San Francisco. You're paid for by citizens' money, and the citizens have a right to know. And so, unless you can explain why they don't, on this one document, then my opinion is, it's something that should be delivered. So, but that's just what I've been.
So. We're going to be required to deliver the document. I think you're going to vote that we.
I think so.
Okay.
Yes.
We'll deliver the document. We'll also look at it. We'll try to look at it before we deliver it. Then you want us to come back?
Yeah, you'll get a communication from our administrator, and we'll talk about that a little bit further. But it'll be a committee. It's not going to be at this.
Oh, okay.
It'll be a little different.
I understand. Thank you.
Thank you. Unless there's any questions. Oh, Pamela. Sorry. Go to you.
Yeah, I find this all incredibly fascinating, and I thought that we were going to have a ad hoc committee to discuss all these matters further. So it's clear we need to do that. I'm inclined to vote in favor of a violation too, but one thing is sticking for me, and that's the issue of exempt information that could be in the metadata. And the problem of scrubbing that exempt information out to comply with other laws, and doing that, if that would corrupt the spreadsheet such that delivering the spreadsheet to that person who requested it, it would no longer be the information he or she sought, because it would be corrupted in the attempt to remove exempt data. So this problem is sticking for me.
If I may, very briefly, I think the issue here is there's been no finding that there is exempt information in this document, so that we can vote on the order of determination of a violation. But your point about how this is complied with, where there has been a showing that there's exempt information that needs to be scrubbed, is a separate and complex issue that we should also be discussing and hopefully setting up best practices for the city, what we're trying to do. With respect, I think, to the narrow issue, my understanding is you can scrub metadata from these documents. If you then click on, for example, an internal embedded link that might disclose something, a connection to a different document, for example, it'll say there's an error in your spreadsheet, and that might be a consequence of scrubbing it. Is that the formulas, there may be errors in terms of how it's computed. It will still be the document scrubbed minus those links. I'm not saying that's appropriate, but if it were appropriate in a certain circumstance because it disclosed internal security measures which the department felt were not subject to release, again, I don't agree, but if that's the reason, there may be ways around that and still provide utility to the requester of the documents with its formulas.
It's time for public comment. Is there any public comment on this item?
I'm a little bit puzzled about all this. I mean, a crook is a crook, and no matter what kind of document or anything you have, if someone wants to tamper with it, they will tamper with it. The U.S. Treasury Department is very concerned about counterfeiters, but they still issue $100 bills and $20 bills. It doesn't make sense. You know, document can be altered.
Any other public comment? Can you call the first question?
Through the chair, Member Craven, is 6253.9?
No, well, that's for the second.
The second,
The
yes.
first question is a violation against,
On
no
time.
violation on the issue of time against the supervisor of records.
6221.
And then the second motion will be for a violation of 6721L and Government Code 6253.9.
Thank you. On the first motion on timing, Member Craven,
To find no violation.
to find no violation.
Aye.
Member Craven, aye. Member Nee?
No.
Member Nee, no. Member Cawthon? Member Cawthon, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
No.
Member Knebber, no. Member Johnson?
No.
Member Johnson, no. Member Chan?
No.
Member Chan, no. Member Goldman?
Aye.
Member Goldman, aye. Member Williams, excused. Member Chu?
Aye.
Member Chu, aye. Madam Chair, we have 5 ayes and 4 noes.
Motion fails.
On the second motion, to find violation of 67.21L and State Code 6253.9.
And for clarification before the roll is called, this is against the DTIS?
This is against DDIS.
Just to clarify with the maker of the motion?
Yes. On the motion, Member Craven.
Aye.
Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan.
Aye.
Member Chan, aye. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, excused. Member Chu.
Aye.
Madam Chair, we have 9 ayes.
And for clarification purposes, absent a motion on the second allegation of the complaint against the supervisor of records, will be no further action on that? All right. Call the next item, please. The DTIS issue will go to CAC because there's been a finding of violation. In order to release the document within 5 days, the order determination will follow. Member Chan?
I have to excuse myself for this one. Or item number, recuse myself for this. Number 8.
Could you please explain, and that's subject to a vote by your peers?
Because I have a relationship with the police department.
And my recollection is that you have recused yourself in the past from items dealing with the San Francisco Police Department, and this body has agreed to recuse.
Yes.
Any comments?
Also, I believe there's also the other issue that there might be a potential financial connections whereby he could not vote on this issue.
Correct.
And I would also suggest that he be allowed to recuse.
Any member comments? Seeing none, can we vote on the issue of Member Chan's recusal?
On Member Chan's recusal, Member Craven?
Aye.
Member Craven, aye. Member Nee?
Aye.
Member Nee, aye. Member Cawthon? Member Cawthon, aye. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
Aye.
Member Knebber, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan?
Aye.
Member Chan, aye. Member Goldman?
Aye.
Member Williams, excused. Member Chu?
Aye.
Madam Chair, we have 9 ayes to recuse Member Chan.
Great.
Members, I move that we find jurisdiction on this item.
Second.
Is there any public comment? Can you call the...
Good evening, I'm Sylvia Johnson, and I noticed you've been planning on certain appeals that do right put our world in trouble, and I think that you've been doing a tremendous job as far as the resolution goes. I know it's been kind of pretty hard to find code with toothpicks and doornails, but I think that you are achieving a lot that has been missing in far as different kind of way of lifestyle. And there's some acting programs that I like to do, as far as this terminology, and I already know that we have been a war battle in my past of the ones that did, achieve the enormous actor that did make everybody happy, and this is all involved with body chemical factors that this has been cut off in a non-wearing project. And I already been knowing that what you've been writing on these papers that has been not factual on these ordinance. And I want to write and tell you on this paper so you understand a lot of these things that have been overridden on my possessions.
Thank you. Is there any other additional public comment on jurisdiction? Seeing none. Can I call the question, please?
On jurisdiction, Member Craven.
Aye.
Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excused. Member Goldman.
Aye.
Member Goldman, aye. Member Chu.
Aye.
Member Chu, aye. Member Williams, excused. Madam Chair, we have 8 ayes.
It's time for the public hearing. Is anonymous person here?
Ray Hartz, and the only reason I put anonymous is so my address and telephone number don't get posted on the internet. I'm here tonight to discuss the issue of the San Francisco Police Department's responsibility under 67.29 to post a listing of all the public records that they keep in their control on the index of records. I have checked with the persons responsible for maintaining the index of records, and they have informed me that at no time have they received any information from the San Francisco Police Department which would permit them to post anything on the website to comply with the law. I did communicate through the internet with the with the San Francisco Police Department, basically asking why they did not comply with this. I was referred to their legal department. I talked to the legal department. They said, this is over our head. You need to talk to somebody else. I said, who do I talk to? And we went around and around. I think it's pretty clear they are responsible for a lot of documents. And one of the things that was provided, I think, by them as a response, in fact, the only thing I can see, was an extensive list which you probably have a copy of, department name, San Francisco Police Department, department contact, Marine Conifray, and a contact number with record category, type of record, and some retention periods. That basically is the only thing that was provided. This has not been provided. I called up the person who maintains the index of records, and they said they've never received anything like this. But if you look at this, there are 2 concerns that this additionally raises. One is that there are also records on here relating to the San Francisco Police Commission, which is covered under the ordinance, and therefore, since the San Francisco Police Department has not maintained provided the information to maintain the index of record, they've also failed to provide the information necessary for the Police Commission to comply. So we have actually an extra issue here. The second thing would be, if you read section 6729, the information they provided here doesn't in any way, shape, manner, or form comply with the requirements of that section. Basically, the section says the index shall be for the use of city officials, staff, and general public, and shall be organized to permit a general understanding of the types of information maintained by which officials and departments, for which purposes and for what periods of attention, and under the manner of organization for accessing by reference to a name, a date, a proceeding, or a project, or some other referencing system. The index system need not be in such detail as to identify files or records concerning a specific person, transaction, or other event, but shall clearly indicate where and how the records of that type are kept. So basically, all we have here is a list of department-wide records, general. What is that? Who knows? Well, it gives you a type of record there. Well, what is that record? I don't know. Who maintains it? Who do you contact? good question. I've gone around and around and around with the police department and made numerous attempts. I've had people ask me a whole bunch of inappropriate questions under the law. Why do you want this information? What are you doing with the information? Who you do? In some cases, I just was open about it and said, this is what I want to do with it, and they hung up on me. I've been referred to 6, 7, 8 different people in a row, all them proceeding then to ask me, why are you calling me? You call their legal department and they say, well, what specific record do you want? Well, it's kind of hard to tell them what specific record you want if you have no idea what records they have. And I've had even people ask me, well, I need to have a specific name and data information to tell me what record you're looking for, or I can't give it to you. Well, if there's nothing on the index of records to tell you what they have, how it's referenced, how it's organized, what it is, anything, how are you supposed to do any of that? The reason I'm asking for a letter of determination is for the length of time that the Sunshine Ordinance has been in effect, they have failed to comply at all. If you look at the index of records, and I did so this morning at 12 o'clock, there is still nothing there for the San Francisco Police Department. Therefore, nobody in the city has any access to what records that they have, and I found it extremely difficult to find anyone who will work with you to help you find what the records are and how to get them. And I would like a determination made in this for one simple fact. Given the record so far, I think this would just go on forever. I need to have something in the record so that if 6 months or a year from now we're still at the same position, I can come back and say, look, we already have a determination a year ago, and we're still here.
Thank you. Are there other parties of the complainant who wish to present facts and evidence? Seeing none, the city have a response?
Good evening, Task Force. My name is Sergeant Jack Hart. I'm an attorney with the Police Legal Office. Also present today is Lieutenant Dan Mahoney, who's the commanding officer of the Legal Division. John Alden is a new attorney with our office, and Miss Maureen Conifrey, who has been kind of our point person for all of the public records requests that we have in our office. She's done a fantastic job, and we have not, thankfully, not that I don't like to see you all, but we've not really been up here for failures to provide documents because she has taken charge and she has been the lead to coordinate the production of those documents. And if you have any pull with the mayor's office on getting the civilianization of the police department, she's the poster child for that. I'd also like to thank Mr. Hartz for bringing this complaint. He does bring up a very valid issue. I don't believe that we are in violation of 6729 because we have a record destruction schedule that's been in effect since 1993. That has been given to the city administrator's office because I had spoken with the city administrator's office in 2004 because they had contacted me seeking an updated record destruction schedule. This was, as soon as that was brought to our attention, so it sounded like they already had a copy of the 1993 schedule. That schedule it's about 50, 60 pages long. It breaks down the types of documents that exist and also where those documents are located, such as the Narcotics Division, Academy, Office of Citizen Complaints, Management Control Division, and it does a rather detailed job of the types of records that we have. Where we would not be in compliance is that record has not been updated since 1993, which isn't the most surprising thing with the police department. We have general orders that go back since 1994 that have not been updated, but this is our record retention schedule definitely has to be updated. This was undertaken by a city attorney named David Carrillo, who was with the city attorney's office, and around that period he had worked on it and then he had left the office and that process had not been picked up. I think that we did get a phone call at Police Legal. It wasn't from any of the people that were present, but someone who does have a general understanding of Sunshine Law inside of our office. And I think the only question he asked was to clarify, which we are required to do under the code, as you know, to figure out what specific document that we need, because we've never had such a request for the master list. If we did get that request, or if I did, I would have provided the record destruction schedule. Again, it's not the most updated thing in the world, because there have been new records that have been generated since 1993, of course, but it at least would have pointed the requester in the right direction. Since then, since we've received the complaint, and that was the extent of the conversation that we've had with Mr. Hartz, we weren't able to respond to him in writing because it was anonymous, and we didn't have I don't think we had a telephone number for him either. That being said, since then, since we've received a complaint from your task force, we have gone to the city attorney's office again. Ms. Molly Stump is our current city attorney. She's made it clear that we are moving forward with this and that we are going to update our schedule. Ms. Conifrey did generate that document. It was based on the 1993 record destruction schedule. The reason that the city administrator didn't accept it is because it wasn't in the right format and the times for destruction weren't updated. So they sent us a sample schedule of what they would like in their format, and there is record destruction times that are in there. And so we can base that on our 1993 schedule, but again, there is a record destruction part of the list that they have in the city administrator's office. That's why I believe that we were in substantial compliance by having that record destruction schedule there with them. That is a public record. Anyone can have it at any time. But we definitely have to get on top of indicating what new records we have and the new destruction schedule. Just very briefly, the city attorney's office has an idea of a citywide policy for what the record destruction should be. Ours is a little bit different. That's the only thing that's holding it up. But because of this complaint, and again, thanks Mr. Hartz for bringing this forward, we're working on it. Were there any questions?
Thank you.
Sorry.
We'll get there. Are there other parties of the city who wish to respond? Seeing none, the matters of the task force for discussion and questions.
I just have one question, I guess for Sergeant Hart. Sergeant Hart, who is the custodian of records at the police department? Is that you?
That is a wonderful point.
Yes, I know I've tried myself to find out. Is it Sergeant Tom or?
No, there's no, not Sergeant Tom. I was actually here, I think, about a couple of years ago when we discussed with the same issue, and there is no one custodian of records for the police department. For instance, I do pitches motions for the department, which is getting peace officer files to the court. I'm the guy who coordinates with the Office of Citizen Complaints, EEO, MCD, so I'm the custodian of records for peace officer disciplinary records.
So how do we get in touch with you?
911? No, I bet still police legal, but generally anyone who's requested public records, I guess this is kind of a drawback for the police department, but kind of a good thing at the same time is that everyone is kind of their own custodian of records. I know it makes it hard to track, hard to know who to ask, and that's certainly true, and that's why legal is sort of the catch-all. If there is a question, submit it to us, Lieutenant Mahoney, Maureen Conifrey, we're all there to get it done. But it's the people, so for instance, if you wanted a General Works file, go to General Works, talk to the exact inspector who would handle the case. You'd get, I think, a much fuller answer on your public records request than me, who's the pencil jockey up at Police Legal, who doesn't know the ins and outs of the case, and I don't know what documents go into an investigator's case file or not. So that's one of the tough parts. There isn't a go-to person like I know the fire department has for the different public records. So I don't know if that's good or bad, and that's, I guess, something that you guys could recommend. But it's unique for the city, so is the police department. But we'll take any feedback that you have on that, and whether we should have a certain custodian of records for all documents in the department, or whether the individual units could be responsible for maintaining their own lists, which they do. In fact, for all our storage, for a GRM, it's the individual lieutenants, for instance, in the Bureau who maintains the lists of what boxes are in storage.
Yeah, well, I don't want to lecture you, Sergeant Hart.
Oh, no, that's all right.
But it does say in the Sunshine Ordinance that a department should have a custodian of records, and my recommendation would be, I've been doing this for a long time, would be that you have Ms. Conifrey for the record retention. Perhaps you could want to expand her job so that there is somebody when you go in there who is the custodian of records, and if they don't have it, they can tell you where to go, because it's really, really difficult to get information from the police departments. I just wanted to mention that.
And I think legal would be that entity, either Lieutenant Mahoney, myself, Maureen Conifrey, and we do direct people in the right direction, or we hunt it out ourselves. I know it's hard, especially with our peace officer schedules. We're on 4, we're off here in this, so it's hard to nail people down who know. But Maureen Conifrey is there all the time and is really who knows exactly who to go to get the stuff, and she's proven that over and over again.
Okay, thanks. Are there any other questions or comments?
I have a question for Sergeant Hart. In your rebuttal, you mentioned the record destruction schedule and a master list. But what this is about is an index of records. You haven't spoken to your keeping of an index of records or your not keeping of an index of records. What about the index of records?
We believe that the record, at least this is what I believe, because the only conversation I've had with the city administrator, it's not like, again, the city administrator has some responsibility here to go to the different departments and make sure that this is on file and up to date. So the only conversation that I've had with them was in 2004, and they said they wanted an updated version of the record destruction schedule, which has a list, and it has a list of the types of documents and how long they're supposed to be kept, which is the current format that the city administrator wants for when we do get our types of records updated. So that information is there within the record destruction schedule, and I believe that that would suffice as a list. If there's a separate list that's required, as in the certain format that they need, it does have a record destruction component to it, so it'll be easy for us to put together in the format that the city administrator wants. I guess it was just my opinion that, or my impression was that the record destruction schedule that the city administrator had was sufficed for all the information that the city administrator needed, because we have not been approached to say, hey, where's your master index list? I've been at police legal for 6 years. I've never heard that. Maybe that's something I was supposed to do and I did not do, but believe that that list would have at least pointed Mr. Hartz in the right direction of the types of files that we have, although not complete, as I said, as we're in the process of updating.
So what you're saying is that you have to be approached
No.
to be reminded
No.
that you need an index? It says
Nope.
here that the city and county shall prepare a public records index, okay? The shall is not like a weasel word,
I'm with you.
right?
I'm
So
with you. And-
Where's the index? That's what I want to know.
Well, I haven't been in the police department for I don't know how long. I haven't been at police legal long enough when that law was enacted, so I'm not sure what previous people had done. All I can tell you is what I've done is that in the last 6 years, and the city administrator's name is in that statute, to have some sort of responsibility, I would hope to
So
get all the members of the city
has
family.
to come to you and tell you that you need to do this? Is that what you're saying? Is the city administrator's problem now?
It certainly would have helped in order to resolve the situation a long time ago if it was not in the format that they needed. And which is also shocking that Mr. Hart says that they never got a record destruction schedule, which I find very hard to believe. But because especially since they approached us for getting updated versions of a document which they never had. So it's over. We're not relying on anybody anymore. Assumption is the mother of all mess ups. And we're not going to be assuming that the city administrators will be taking care of this anymore. And this is something that we are now, first person, going to be responsible for. And we are going to get fixed.
So have you started making this index that's referenced in this complaint?
Yes, we have. Ms. Conifrey has done that. It's one of the attachments. It was on item agenda number 8 today. That's not complete. It's something that we're in the process of updating based upon the information that the city attorney, who I told you is no longer there, some of his work product we have, and we're going to incorporate as part of this, as well as any other documents that have come out, like our new community policing form just came out in 2008. Well, geez, that's something that we're going to be adding to the list, or at least in the categorized in an area of documents, so that anyone who wants it can have a copy of it.
Thank you.
Now, Mr. Hart, give me an estimate. You indicated a couple of times that you started working on it. Ballpark, how long is it going to take to get the department up to speed on this?
Based on the work that was done in 2004, and that we sort of have an index to work from on the record destruction schedule, again, it requires approval from the city attorney's office. I'm not sure how long it's going to take. I can report back to the commission at any time, maybe the next meeting on the 29th, or give you at least some update as to what we've done over the last few weeks. But it's just, again, I'd like to request an extension because we have to consult with other interested city agencies. So, but that's from the code. But no, it's going to take us a little bit of time just to hammer down the people who are actually in control of, or I'd like to say, you're going to have to give their 5 cents worth.
Okay, a couple of comments. Sure. First of all, the section in question, 67.29, is part of the Sunshine Ordinance that was passed in 1999 by the voters of San Francisco. That's a little over 9 years ago. That seems to me to have been plenty of time for this index of records to have been developed, plenty of time for it to be posted and maintained on the website. Second, although it's not part of his complaint, Mr. Hart has mentioned during his testimony that a number of times he or other people asking for records have been asked to explain why they want the record. It is illegal under the Sunshine Ordinance and the California Public Records Act to ask that question.
No, that's absolutely correct.
You might send a cautionary note around to every person involved with handling public records in the police department.
Yes, sir. And that's also the hard part for us, because we've designated so many people to be responsible for records, that it's just something that I'm going to have to put out as a department bulletin as a reminder on how to deal with these requests. It would be easy if we just said, hey, we're the only shop in town and come to police legal because we know that upside down and left and right. But it might be doing a disservice to the public in order to find exactly the right documents that they want. And that's that balancing we were talking about.
I'm just going to repeat what I said earlier, that as someone who has tried to make requests to the police department for public documents, it is incredibly difficult. I have finally gotten to the legal people who have been helpful, but there have been other people who I have encountered before who have been really rude. So now, Sergeant Hart, you seem to be really gung-ho in taking it over. You've got a foundation for your index and that records retention list. I would just urge your department really to comply with the Sunshine Ordinance, to appoint a central person, maybe somebody in legal, who can then spread it out to whatever department you think. But with your good offices, that will make it a lot easier for a requester to get the information. I, too, was asked why I wanted to have the information. I let it go because I was concerned with the information, but that is definitely a no-no. But I would urge this department to take the lead in complying with the Sunshine Ordinance, and the first thing is appoint a custodian of records, and number 2, comply with the index of records. Thank you.
According to our process, the city now has 3 minutes to present any clarification or rebuttal you might have.
No.
Thank you. The complainant has 3 minutes also if you have any clarification or rebuttal.
Again, I want to make it very clear that my complaint is not regarding an inability to get any particular document or whatever it happens to be. It is the fact that the index of records is required to show what records the police department has. It does not have that. I have checked with the person who is responsible for maintaining that index of records, and they have said that they have never at any time been given anything that was indicated to them to be something that the police department would be using to comply with this requirement. I've looked at the document that was provided here, this 27-page long document, and again, it doesn't come anywhere near to what the index of records, I think, requires if you read it, because the index of records is required to give you some idea as to exactly what that record is, who maintains it. We've had testimony from Mr. Hart, or Sergeant Hart, that there are custodians all over the place, and that's what I get. You call up and it's which document you want, what's the number, what's the subsection. Well, that's this person. You get connected to that person, and they refer you to somebody else. They'll ask you, why are you calling me? And you just go round and round in circles. The bottom line is they haven't complied with it. They are not in compliance. I would like a letter of determination that they are not in compliance. And as a result, I would like that be something that would be available, that is on the record, so that 6 months or a year from now we're still at the same position, because unfortunately Sergeant Hart has not given us a substantive answer. I can see this exactly going on for another 9 years. One of the things that he mentioned was this, the history of the record destruction. That may very well contain all the information, or some of the information at least, to update the index of records. But I think it is the responsibility of the police department to indicate to the person maintaining the index of records that this is not only to give you the information about the destruction of records, this is also to be used to update the index of records for public access. So I don't think it's the responsibility of, I heard that argument made that, well, it's their responsibility. No. If I was in the military for a lot of years, and bottom line is, if I ever said to somebody else, no, it's the other department's fault, I would have been told, no, it was your fault, and if they didn't do it, it was your fault to go see why they didn't do it and make them do it. And if you had a problem with that, you should have come to me and let me know. And between the two of you, one of you should have done it. And if nobody had, one of you or both of you should have come to me and explained why. And so really that's what I'm seeing here, is that the responsibility being foisted off on one person or the other. I think it's the responsibility of the police department to have the record. It is their responsibility to give it to the person maintaining the index of records. It is their responsibility to get it on if they have questions, to go back, and so forth.
Thank you. The matter is with the task force, or motion? Deliberation? Or comments, please?
Yeah, I just want some clarification about section 67.29. About midway down, it says the city administrator shall be responsible for the preparation of this records. Oh, okay. All right, thank you.
Move to find in violation of 67.29.
Second.
I didn't go.
Also, as a body, as a task force, it seems like it's our job to help educate other city departments on Sunshine. So maybe attaching something to be referred to EOT in the future.
Yeah, I think that can be done outside the motion, but that's where I think it should end up.
Yeah.
And you're right. Maybe we could talk about it, citywide. Make sure every department has it.
We can bring it up on Thursday.
Time for public comment.
Hi, Kimo Crossman. First of all, I want to thank Ray Hartz for bringing this up. I actually never understood the power of this section until I just read it closely today. One of the things I never realized was that it actually requires that they have it says under the manner of organization for accessing by reference to a name, a date, or a proceeding or project, or some other referencing system. I don't think any of the index records, any of the index of records that I've seen given by departments have an accessible method. They don't tell you, how is this organized by name, date, project, or other referencing system. This one surely doesn't. So that's something I didn't realize, and I'm going to definitely be looking at the ones departments have created. The other thing that I found interesting was that the appropriate policy body has to adopt this. So I would think it requires a formal adoption by administrative official policy body responsible for the index records. So I believe that means that the Police Commission needs to adopt this index of records, which obviously they haven't done. And it says the index shall clearly and meaningfully describe with as much specificity as practicable the individual types of records. That's actually pretty darn detailed. And if you look at this index, what they provided, I don't think that's very specific. I mean, clearly, meaningfully describe, specifically as practical. That's incredibly specific language. And the last thing I noticed, which I found really surprising, is it says that any changes in a department, agency, or commission, or a public official's practices or procedures affecting the accuracy must be provided to the city administrator and shall be recorded. So they make a change, they have to update it. I'm sure that hasn't been done by any department in the city, and clearly, obviously, it hasn't been here. And then it also says the index shall be continuously maintained. Obviously, that hasn't occurred.
Is there any additional public comment?
Could I ask one more question?
Let's finish public comment. Let's finish public comment. Is there additional public comment?
Good evening, I'm Sylvia Johnson, and I have seen some things that caught my eye with the cops, and I was so surprised. And I was going to go in there, but I've been with the wrong company. So if they're going to have, some problem with getting our land right, that's, as said, under cover, but out the horse's mouth. When you hear of things happening, and they won't ask the person what's going on, then, and then there's physical things on top of that, which is, get a whole lot to do with it, getting public and everything right with the police department.
Thank you. Is there any additional public comment? Ms. Coffin, do you?
I just had a question for Sergeant Hart. You look like you're dying to say something, so if you are, I'd like to hear it. But let me just ask you a question first. I chair a committee on outreach, and one of our new goals is to preach the ordinance, the Sunshine Ordinance. So we'd love to get in touch with somebody at the police department. So should we was it you? Is it Lieutenant McConey? Is it Maureen Conifrey? Or could you give us, it would help so much if you could just give us a contact number.
I'd be happy to do it.
Okay, so
Jack Hart, H-A-R-T.
Got it.
My number's 553-1322.
Got it. Okay,
I'll also give
thank
you Lieutenant Mahoney's number as well, M-A-H-O-N-E-Y, and it's 553-7929.
Okay, thank you very much. And if you had anything you seemed like you wanted to say something. So
Just the attachment that you guys have for number 8 today is just a draft. It's not in the proper format.
That's fine. That's fine.
We're on it.
Thank you. Good. Well, thank you.
Let's call the question.
On the motion to fine in violation of 67.29, Member Craven. Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon.
Aye.
Member Cawthon, aye. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams excused. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 8 ayes.
Just for my clarification, where does the chair believe this should be referred to?
Education outreach. Great. Thank you. I think that's the end of the agenda.
See you in 1 week. Huh?